as it has come to exist in this country, is attempting to hold a delicate balance between the need to keep this country and its people safe and the need to preserve and protect the individual liberties that have made this country great over the years. Now, the idea of foreign intelligence surveillance and of a special court system to monitor those activities is of relatively recent origin. When I was a young lawyer and dinosaurs roamed the earth, there were no such thing as the FISA courts. Those courts came into being in 1978 when Congress passed what was then a novel creation, the Foreign Intelligence Surveillance Act, which for the first time codified a regime for the electronic surveillance of enemy powers, agents of enemy powers, and the like. It set up that regime with great attention to protections, both protections to ensure that that power would not be used to target United States citizens, particularly for activities that came within the purview of freedom of speech and freedom of expression, but also adorned it with probable cause requirements, with minimization requirements. And for those of you who aren't familiar with the general concept, anytime you conduct some type of surveillance, you intend to acquire certain types of information, but you may very well inadvertently require other types of information. Minimization is a way to shed, to make sure that government doesn't retain and use for an improper purpose material that it wasn't intended that it acquire through the surveillance. And as one of the protective layers in this regime, Congress created the FISA courts. And as Rick said, there are two. What we on the inside call the FISC, FISC, the Foreign Intelligence Surveillance Court, and its big brother, the FISCR, the Foreign Intelligence Surveillance Court of Review. I'm going to talk a little bit to you about the structure of those courts and give you a bird's eye view of how they actually operate in practice. But before I do that, and before I go through the expansions that have taken place in the matters that are committed to the jurisdiction of the FISA courts, bear in mind that there are three types of limitations that apply to all of these activities that are undertaken by the government, even before we get to the question of judicial review. One type of limitation is immutable. That's the protections provided by the Constitution. The government cannot be allowed to do anything that would offend those protections. The second type is much more flexible, and that's legislation. Congress cannot authorize the intelligence community to do things that the Constitution prohibits, but it doesn't have to authorize the intelligence community to go right up to the edge of what the Constitution permits, and indeed can draw that line as to what is allowable well short of the constitutional limit if it so desires. And the third type of check, which is little commented upon, is in the executive branch of government itself, because the fact that the intelligence community and the agencies within that community are authorized by the Constitution and by statute to do certain things doesn't mean that they must do those things, particularly if the executive, the president through the Attorney General, through the Director of National Intelligence, demands a lesser course, doesn't want things pushed to the absolute limit of the statutory and congressional powers. So you've got those three levels of potential checks, and then you've got superimposed on that this special court regime. Many people object to the courts and the way they operate in this area because they operate in secrecy. And I submit to you that that is not novel, nor is it unprecedented. If you think back to the way the criminal courts operate in this country and have operated for over 2 centuries, surveillance activities of law enforcement are typically conducted ex parte, that is, with only one side represented, and in secret. When the Providence police want a search warrant to go in and seize contraband from the home of a suspected drug dealer, the city solicitor or the attorney general who's handling the case meets privately with the judge. The judge hears from only one side. The proceeding is not publicized. And the reason is obvious, because if the target of the investigation were to realize that it was imminent for a search warrant to be issued, the contraband would disappear. If the target were to realize that a wiretap was being requested, the suspect simply wouldn't use that telephone to conduct their dealings. So the concept of secrecy in connection with foreign intelligence surveillance really follows in the tradition of how these matters have been handled in the American court systems. The FISA regime, when it was put in place in 1978, was expanded and amended to some extent in the mid-1990s. That expansion really got away from the idea of pure electronic surveillance and authorized the intelligence community to consider and the court to authorize things like physical searches, pen registers for telephonic communication, so-called trap and trace procedures. Not a major amendment. The two major amendments to the regime, the first came in 2001. What we all associate with 2001, the Twin Towers, 9/11, and the world changed. Right? Congress responded by enacting the Patriot Act. And the Patriot Act not only extended the FISA regime for the first time to business records, right, but lowered some probable cause requirements to reasonable suspicion, and in many ways gave more clout to the intelligence community. Now, it did that. It wasn't completely one-sided, because it coupled that with expanding the requirements for certification, not only by the Attorney General, but now by the newly created Director of National Intelligence. It did so by insisting on more effective minimization procedures. It did so by capping the length of time for which a surveillance could be authorized or could be extended by carrying with it requirements for what I think of as negative probable cause certifications in some instance. But certainly the foreign intelligence surveillance, that became a growth industry starting in 2001. And in 2008, the last major amendments to the Act, what I think of as the FISA Act amendments, or which some people call the Patriot Act amendments, no difference, gets you to the same place, carried that trend a little further, but reflected some growing concern with how the administration and the intelligence community had been using the powers granted by the Patriot Act, and so built up the safeguards even more. So that's the plateau on which we operate. The courts themselves are unusual in the fact that they are staffed by judges who have full-time responsibilities elsewhere. It's a peculiarly American and wonderful concept that you can take a busy federal district judge who's underpaid to begin with and who has a full docket in say Seattle, Washington. Pick your city, and say to that judge, now we want you to devote, all right, a minimum of 1 week every 2 months to coming down and sitting in this special court in Washington and doing lots of extra work on matters of very great consequence. And of course, we're not going to pay you anything extra for it, and we're not going to lighten your caseload back in Seattle by one shot. And yet, I dare say that you probably couldn't find a federal district judge in this country who wouldn't accept an appointment from the Chief Justice, despite those seemingly disincentivizing economics. All right. So by statute, the Chief Justice selects 11 judges for the FISC, 11 district judges, 3 of whom have to be in the Washington area for practical logistic concerns, because if emergencies arise, that's where you're going to need judge power. The other 8 have to be scattered through the country. No more than one can be from any regional circuit, as we call them in the trade. And Congress was, I think, quite perceptive in limiting the term of any judge on either the FISC or the FISCA to 7 years and making that non-renewable, because there's been too much experience in Washington of regulated industries co-opting regulators. Congress had a concern that you don't want the judges to be there long enough that they develop real relationships with the people in the intelligence community who they're supposed to be policing and monitoring. The FISCA is composed of 3 federal appellate judges, all of whom have full-time responsibilities elsewhere and no extra pay. And the only requirement there is that the Chief Justice select 3, each from a different circuit. So when I first became, when Chief Justice Rehnquist first appointed me to the FISCA, I was serving with a Court of Appeals judge from Detroit and with a Court of Appeals judge from Portland, Oregon. At the point I left, my colleagues were a Court of Appeals judge from New Haven and a Court of Appeals judge from Little Rock, Arkansas. And so you have that sort of variation. Here's the way the FISC, which is the busier of the courts, actually works. They have a staff, the way any court does. That staff includes 5 full-time staff attorneys. The government decides it would like to conduct a particular type of electronic surveillance against a particular target. It files a proposed application with the FISC. That proposed application is reviewed by a staff attorney who makes sure that it complies with all the formal requisites, that the required certifications are attached, that the length of time the surveillance is projected to last doesn't exceed the authorized limits, et cetera, et cetera. The staff attorney may contact the government attorneys, ask for additional information, ask questions to make sure that he or she has everything in perspective, and then transmits the proposed application and any additional information to a judge of the court. The judges have what we call a duty judge system, where they rotate through to whoever is the duty judge for that particular week, along with an analysis of the filing, and usually with a recommendation. The judge then examines it, but the key is we're dealing here with a proposed application. The judge examines it, and the judge at that point can do one of 4 things. He can have the clerk's office notify the intelligence agency that he intends to approve the application, in which case the government will come right in with a final application that mirrors the proposed application. He can tell the agency that he'll approve the application or will consider approving the application if certain conditions are met or certain amendments are made. The government may file a final application that meets those conditions, or it may at that point decide the conditions are too onerous and withdraw the application, or it may file a final application that doesn't meet all of those conditions and request a hearing and attempt to convince the judge that the application should be approved. Or the judge, the third option, may notify the agency, I can't commit myself on this. You file your final application and I'll hold the hearing on it, and I'll decide after the hearing. And fourth, the judge may say, I can't see any way in which I'm going to approve this application. You go ahead and file it in final form if you want, but you want to know which way the wind is blowing. The result is, the net result of all of that is that that process weeds out most of the applications that would have been denied because the government at some stage along the way decides that it's not worth pursuing the point, abandons it, withdraws the proposed application, never files the final application. So when you hear statistics, which are often bruited about there being a huge, very high approval rate of these petitions in the FISC, that's an approval rate on the final petitions. Sure, those are 99% approved because the judge has almost committed in advance to approve them before they've been filed. The ones that the judge was going to deny, the government has withdrawn or abandoned. And if you factor the abandoned and withdrawn applications into the mix, what you get is that the government is getting approvals something around 73–74% of the time, not the 99% that opponents of the system like to say. The FISCR is a wonderful court to serve on because it doesn't have much business, all right? The reason it doesn't have much business is that most of what the government wants to do is time sensitive. So that if the FISC judge denies an application, the government then has to consider is not only the chances of prevailing on an appeal, but whether there's going to be any value to prevailing on an appeal, because that appeal will consume a certain amount of time, measured in weeks or months. It will be substantial in relation to the needs of the intelligence community. So those appeals are few. But there is another type of proceeding authorized especially under the Patriot Act and the FISA Act amendments, which has generated some appeals. And that is Congress has given to the Attorney General the power to issue directives to third parties in aid of authorized intelligence investigations that come under the jurisdiction of the FISA court. And if the service provider, let's say, as a third party, let me take one of the few reported cases, and I'm going to talk to you in a minute about the lack of reported cases, because that's one area in which I think the system has to improve. But in one case, a service provider, unidentified for reasons of confidentiality that were owed to the provider, has since become known at its request, because it wanted its name associated with this, happened to be Yahoo, refused to comply with the order, felt that the directive itself was an unconstitutional exercise of the powers granted by the Patriot Act. They went to the FISC judge issued an order to compel production. Yahoo then appealed that to the Court of Review. So that's the type of proceeding, these third-party appeals, that have made the Court of Review more active. Just by way of incidental information, the FISC itself, the FISC court, the trial court, always sits in Washington, has its own courtroom. We've got all sorts of special protections for that courtroom. But the FISCR, the appellate court, is authorized to sit anywhere in the country at the direction of the chief judge. And the Yahoo case, which has become the subject, since it dealt with the so-called PRISM program, and has become the subject of a lot of discussion now, was actually argued right here in the courthouse in Providence, in the courtroom now used by Judge McConnell. No one knew it at the time. It was all under seal. The Solicitor General was here to argue for the government. The entire, not only the courtroom, the entire floor of the courthouse was sealed. And there is a certain cloak and dagger element to what goes on. I'm going to speak to that in a minute. But let me, as long as I'm talking about opinions, let me tell you, to my mind, one of the faults in the system is that not only are the proceedings secret, but for most of the existence of the two FISA courts, the opinions of the court have been secret and have been kept secret long after the matters that those opinions dealt with were resolved and over. And when I became the chief judge of the FISCR, the chief judge of the FISCR has some administrative responsibilities for the entire system, which kept me fairly busy. But I attempted to see if we could, both at the FISC level and the FISCR level, publish more opinions, even if we did so in redacted form. And we immediately met a stone wall because the national security folks were very resistant to declassifying anything, right? And so what would happen is you would say, we're going to issue this this opinion. So it's not a question of declassifying the entire opinion. It's a question of redacting it to assuage your national security concerns. And the draft would come back with everything struck out except two thes and maybe an of, all right? And you know, you would then engage in this ping pong match with the people. But when push came to shove, it's a very difficult thing for a judge who doesn't have deep grounding in matters of national security to argue with a high-ranking national security official who's insisting that national security will be jeopardized if we say more than we want you to say. Now, what we started in 2009 and 2010 has borne some fruit, and a small number of opinions in readable, redacted but readable form have been made available within the last 12 months or so. I hope to see us make more progress in that direction. Let me close these remarks by telling you something which gives me great hope for the future and has given me great inspiration. The professionals, I'm not talking about judges now, but the professionals who work within the intelligence community, charged with responsibility for national security in this country, are the most impressive group of individuals that I've ever had occasion to work with. They are dedicated, they are smart, they are tireless, they are patriotic, and they are sincere in their efforts to do things within the letter of the law, perfectly willing to go right up to the edge of it, but dedicated to staying within it. Now, that's not to say that I don't have some war stories that I could tell you, most of which center around the fact that I have yet to meet anyone in any of these agencies who has anything approaching a sense of humor. All right? I found that out in the first week that I was chief judge of the FISA. I had an invitation from Keith Alexander, General Alexander, who heads up the NSA, that he thought I would function better in working out some of these protocols with the Attorney General if I really saw the way their operation worked. So they drove me out to Fort Meade, Maryland, and I spent an entire day, dawn to dusk, walking around with General Alexander, looking at their 8,000 employees at that one facility, seeing what everyone does, how they do it. The technology is amazing. We had lunch with the Director of National Intelligence and the Attorney General in General Alexander's dining room, and at about 5:30 in the afternoon, the tour being through, General Alexander and I are standing on the front steps of the facility waiting for his driver to come around and collect me so I can get back to the hotel in Washington and find out just how much shopping my wife had managed to do that day. All right? And General Alexander said, I thanked him very much for an extraordinary tour, and he said, Judge, he said, we think things like this are useful. It would be our pleasure if you would come back every 6 months, because things change so much in our line of work. We'd we'd like to keep you current on the changes. And with what I thought of as a humorous twist, but which Cindy says is my penchant for getting in trouble, I said to him, well, Keith, I said, that's a very kind invitation, but when I come back the next time, I think I'll bring my teenage grandson with me because he'd understand this technology a lot better than I would. All right? And he didn't bat an eye. He just looked right at me and said, what level security clearance does he have? Now, I should have learned my lesson at that point. I don't think I really did. Because the next week, bear in mind, I'm brand new as the chief judge. I get a call from Washington saying they have a document that I have to look at, but we have no sufficiently secure communications. So they are having a courier bring the document to me. And would I be available later that morning? Because his plane was getting in from Washington around 11, I said, fine, have him, have him come right to the courthouse. I'll wait for him. Around 11:30, quarter of 12, in walks fellow, makes me feel like I'm in a B movie. All right, he is, not a word of a lie, wearing a trench coat, all buttoned up, has one of those attaché cases with a chain chained to his wrist, and he looks around furtively, and I welcome him into my office. Now, I have a lovely corner office in the courthouse, which overlooks College Hill from one set of windows and the State House from another. And he comes in and closes the door behind him without saying a word. And before I can ask him to sit down, he puts his finger over his lip, goes over and he dismantles my telephone. And I said, pardon me? He said, oh, there's some new device around where they can convert your telephone to a listening machine. He said, I have to do what I have to do. He goes over then and he starts tugging at the drapes. Well, I have drapes which are purely decorative. They don't close. All right? He gets very frustrated. So he puts down the Venetian blinds. You know, this huge dust motes arise because I haven't used the Venetian blinds in years. And I say to him, again with my sense of humor, oh, you must be afraid that whatever you're going to show me will be observed by those subversives up at Brown. To which he replies, not just Brown, RISD too. Now, when he finally gets around to opening the attaché case, pulls out this single piece of paper, I break the news to him that I have no reading vision. So he agrees that he will. I said, now we have two things. I've got this big machine, I can put it on there, or you can just read it to me. Well, he elects to read it to me. I can't tell you the contents, but what I will say is those contents were about as deserving of being couriered up from Washington as the back of a milk cart. I mean, just an absolute routine piece of business. But this went on for, 3 or 4 weeks. 3-4 times a week, we'd have a courier flying in, most of this worthless. So I finally got on the phone to Mike Mukasey and raised a certain amount of hell and said, you're going to find some money, set up what, I love government acronyms, got to set up a SCIF, all right? Don't ask me what it stands for, but it means Secure Communications Facility. So they came in and they set up one of those red phones like you see in the Hillary Clinton commercials, all right, which can only be activated by my thumbprint placed in a specific thing, and a secure fax and secure email. Now we've got everything all set, except they're going to send me all these documents, but there's no place to keep them because there isn't a safe that meets their security requirements. So the documents are being kept for the next couple of weeks in the FBI office, which is the only, according to them, the only secure safe in the state, and which is relatively inconvenient, to go back and forth there. So I recall from having been a federal judge for too long that the courthouse we're now in was the original post office in Providence. And I recall having seen on the mezzanine of our courthouse, which is like a glorified junk shop, all sorts of things that will never be used, this huge safe, which used to be the postmaster's safe. So with cooperation from the clerk of the Federal District Court, we got the floor reinforced at a spot in my chambers. And we have this huge 4-ton safe, all right, which absolutely impregnable, all right, brought up. And we've got it all fixed. And they send the appropriate person up from the DIA, the CIA, whichever agency had that duty, inspects it, decides that the safe is fine, but the locking system isn't up to par. So they fly a locksmith up from Washington. This locksmith installs the most complicated combination lock that you can imagine. Now, bear in mind, security requires that only I have the combination. But I can't see anything, all right? Do any of you remember the Mr. Magoo movies? Well, there I was trying to open this. I mean, this is the way your federal government works. But these people are sincere, all right? They want to get things right, and I think that we're awful lucky to have them. Now, that's just kind of an overview of where we are, and I'm happy to answer any questions. But
thank you very much. Over here in the seat. That was great. And so I'll moderate the discussion. So if people want to ask questions, we have some time. And if you could please identify yourself when you ask the question. Yes.
I'm Josh. I'm an undergrad here.
Okay.
You mentioned that nice little anecdote about your grandson and the technology and whatnot. And there's been a lot of talk in the media and among sort of privacy circles about how Congress and a lot of the judges don't really have a good conception of exactly how the technology works in regulating. Do you think that is problematic? That leads to decisions that might otherwise be made differently by someone who has a better understanding?
I can't say whether it leads to decisions that are different, but I don't think it's problematic. And the reason I don't think it's problematic is this. Federal judges are by definition generalists, all right? So that any federal judge worth her salt, all right, is dealing day in and day out with things that she doesn't understand until she has to understand them in a certain context. If you're going to preside over a complicated products liability or medical malpractice case or any of 100 other cases that I can think of, you don't know the ins and outs of what's happening until you learn how they operate in the context of that case. And I didn't have any trouble in figuring out what I had to know about the technology. I didn't understand all the ways in which the government was getting information, but I understood pretty well what information they were getting and what justification they had or didn't have for wanting to get that information.
Great. Yes.
Hi, I'm Peter Margulies from Roger Williams Law School. Judge, there have been recent suggestions which President Obama has embraced to create a panel of attorneys that will supply a different voice at the FISC. And some people suggested that should be a more institutionalized alternative with an ongoing presence at the FISC, which will oppose the government with respect to particular requests it makes. Do you think some kind of alternative voice is appropriate and productive?
I think it's an awful idea. All right, for the same reason that I would think it's an awful idea if you told me that the federal district judges here were no longer authorized to issue search warrants or telephone taps unless some third party sat in and monitored the reasonableness of what they're doing. That's what you've got the judge there for. Judges are used to sizing up these things and dealing with with whether they measure up to the constitutional constraints or not, and making an adversarial process out of this type of surveillance request, which nowhere inside or outside of the FISA regime has ever been adversarial in our system, would I think slow up the process and would really jeopardize the ability of the government to respond as quickly as they have to exigent circumstances as they arise. There's already some concern within the system that the courts can't react fast enough because we insist on taking certain amount of time to consider things and make reasoned judgments, and I think to slow the process up further for what I think would be no real gain, I'm just opposed to. That's. But if you want to know what I really think.
Okay. Yes.
My name is Tim Peacock. I'm around class of 2012 and until recently was with the Brookings Institution in D.C. To what extent do you think the logic in U.S. v. Jones, where the judges consider GPS tracking devices with costs of surveillance, how do you think that's relevant to the situation? And should we have evolving standards for surveillance as the costs keep going down?
I'm not sure. I'm not sure Jones is directly analogous, but I do think we should have evolving standards. But quite frankly, we're going to need some guidance from the Supreme Court. The Supreme Court has not really weighed in on many of the cutting edge issues that are emerging. And we're going to have to see some of that. You see it most clearly in the PRISM situation, where the FISC, in its most recent decision, is applying a 1979 Supreme Court decision, which says that the business records associated with your telephone calls, the non-content metadata type records, all right, that there's no privacy interest in those. I think the perfectly good argument can be made that times have changed enough and the technology has changed enough that maybe there is a privacy interest, all right? But the Supreme Court's going to have to say that, because I can't blame or even criticize a federal judge like Judge Egan of the FISC, who says that's the law that the Supreme Court has announced, and until they change it, I'm sticking with it.
Yes.
I know that FISA stands for Foreign Intelligence. But how do you draw the distinction when you're making the determination between what is foreign and what is domestic, where you have a combination of the two in the matter which is being sought?
Yeah, Mel, that's a good question, and it's a difficult distinction to draw. Now, bear in mind, a lot of the information that's being sought under FISA, I'm always hesitant to say all of it, all right, but I'm hard-pressed to think of an exception, all right, is either directed outside the United States, foreign in that sense, or within the United States, is related to what the statute calls non-U.S. persons, which are basically foreign governments, agents of foreign governments, or foreign powers, because you pick up things like Al-Qaeda. And I haven't seen that as a real concern. Part of the reason it's not much of a concern is that if it's possible to identify something as domestic rather than hook it into foreign intelligence, the FBI at least seems to me to be more eager to go through the ordinary criminal courts because they have a lot less red tape and that process moves much faster. So I just haven't seen that as a problem. I understand what you're getting at, but I haven't seen it in practice as a problem.
Great. Yes, Mark.
Judge Mark Schlissel, can you, without requiring the cone of silence or some other high technology,
Yeah.
talk us through how you would analyze a hypothetical but difficult case of the type that this law applies to?
Well, part of it is the same type of analysis that judges make every day in the criminal law area. The application tells you, in effect, what the government wants to do and tells you why the government wants to do it. So you start with that as a guide, but the certification requirements, all right, then tell you what facts constitute probable cause for the government to believe that the underlying facts in that application are really so, or where they're leading. Do they have probable cause to believe that particular activities are occurring, that those activities are occurring on particular places, are using particular means of communication? So it's the same type of analysis that I would apply if I got a search warrant application from the FBI or the DEA when I was a district judge, and it's not too different from the analysis that judges apply to their cases where they are trying to add up verified facts, measure them against pretty clearly written statutes and fairly well-defined legal principles, and see what comes out the other end. But I can't really give you a much better answer than that. It's almost a Potter Stewart type answer that you know it when you see it.
Like pornography?
Yeah. There may be some parallels.
Okay. Let's get Sue.
Hi, I'm Sue Eckert here at the Watson Institute, and thank you for that. I think that was a great clarity for a lot of people who don't understand this system. But I'm curious, as an early proponent of greater transparency in terms of publication of decisions, what more do you think could be done now? And how do you try to level the playing field just in terms of, I've been in situations with those same officials, and you can't argue with them because they have access to information that you don't.
Right.
So how do you confront that, and how can we move forward on having greater transparency?
All right.
now?
What you've got to do is you've got to go over their heads, all right? Because the direction is set in these agencies. These are very much top-down agencies, and you've got to get the people at the top to understand. The easy thing for someone, let's say in the Defense Intelligence Agency, the easy thing for someone there is to say, keep it all classified. We can't possibly get into any trouble that way. So transparency is foreign to what they want. So what you've got to do is got to go to the ranking officers, all right, the top generals, and convince them that if they and their people aren't more willing to be reasonable about classification decisions that assist transparency, that they're risking severe changes in the system because they're going to wind up with a public reaction, an adverse public reaction. I don't know any other way to do it, but I do know that I had much better luck on issues of that type dealing with the agency heads than with the people who were actually making the classification decisions on the ground, and to some extent was successful in getting word filtered down.
Okay. Peter.
Thank you, Judge. Peter Andreas, Watson Institute. You've done a really great job of helping us understand how the system works. I'm trying to get a better sense of whether you think the system works, and how it could work better, and whether you think, I guess to be provocative, I think anything positive has or will emerge from this, we call it the Snowden scandal, in terms of reforms that are now being contemplated or already being implemented in this regard.
Well, all right. First of all, I do think the system works. It's not perfect. You know, it's kind of like it's kind of like democracy itself. You know, it's not a great system, but it's better than any other system that I know. You know, would work. And I'm, as you might guess, not a big fan of Snowden. I think that his activities are treasonous. But I do think that cloud does have a silver lining, because I think some of the discussion that has been sparked will lead to some reforms. And I think we've seen some evidence of that now. I mean, there has been some loosening, just in what we were just talking about, in the declassification of opinions. Right? I think that's directly related to the furor that came up about Snowden. And I think it's wonderful that we have a dialogue about this, and that people try to figure out ways to make the system better. Of course, the president appointed a commission to look into it. I'm sure you're more familiar with the commission's report than I am, and they came up with, I don't know, 32 or however many suggestions that might improve the system. Now, I thought most of those were not improvements, but I thought some of them were worth considering, and the president himself seems to have walked away from most of them, but has indicated that he's, you know, willing to exert some capital in favor of 4 or 5 of them. How do you give more protection to this metadata that's being held by the government? Let's talk about whether it makes sense to have a third party hold it. What I think may make more sense is I've never figured out why it has to be kept for 5 years, so it may result in a shorter retention period. But I don't think we're at the final chapter yet. I think this is ongoing, both in terms of how we can do this better, so as to strike the right balance we want between security and liberty, and how the system has to adapt to take account not only of changing technology, but changes all throughout the world. I mean, don't forget, this system was devised originally in 1978, when the concern was the Cold War. You know, so people in Washington were concerned with good reason about the Soviet threat. Well, the threat that the people are most worried about now isn't the nationalist threat. It's it's the threat of terrorism and the groups that are not organized as nations, although nations are enablers to some of these groups. So and as that template changes, I think we've got to be prepared to make adjustments to this system. I'm all in favor of tinkering with it. One thing that I think might be a useful improvement is to set up a relatively permanent group, and that would be required on an annual basis to report back with suggested, an assessment of how the system is working and any suggested revisions to it, because I think things are changing that fast.
Great.
Hi, Judge. You were very
You just
clear.
introduced yourself, Tim.
Oh, I'm sorry. I'm Tim Edgar at the Watson Institute here at Brown.
And
Now, Tim didn't introduce himself either because he thinks correctly that I know who he is, or because he didn't want to publicly admit his association with Brown. So you've got to figure out, it's one or the other.
No, very happy to associate with Brad. It's a delightful place to be. So I guess you've been very clear about your concern around the public advocate suggestion. And I guess I don't think I'm gonna convince you that it's a good idea, but I was gonna want to get your reaction sort of two ideas about why it's not the same as a search warrant or wiretap order in a criminal case. And so one is, you don't have suppression hearings, pretty much. I mean, the purpose is to gather intelligence, to use it for government action.
Yep, that's right.
So, in the criminal system, yeah, it's ex parte and it's secret to start with, but there's an expectation that at least some of the time it's going to be tested in court.
Yeah, after the fact, yeah.
The other kind of difference, so you don't have that discipline, and that's a problem. The other difference being that you have big programs that the FISA court is in charge essentially of authorizing and regulating, not just a single wiretap, but a big bulk collection program with lots of detailed rules.
Yeah.
And that's almost like an administrative agency where you have then the opportunity for judicial review. So do either of those two differences make you think that there would be value in having some additional participation if it could be done without slowing it down for important time-sensitive reasons?
Yeah, but the first, with all due respect, I think is almost irrelevant, because the question of how you remedy abuses, that's a whole separate discussion. It seems to me that has, in my mind at least, very little to do with what is the fair and efficient way to get this done up front. The concern about the bulk data, I think that's a valid concern, and I'd like to. I just don't think that it's an effective way to address it through a privacy advocate. And I say this with my heart in my mouth, because I don't have boundless faith in Congress, but I almost would rather see Congress tackle that and see some provisions that are addressed more specifically to that type of activity put into the statutes.
Yes.
So,
If you can introduce yourself, please.
yeah, well,
Yeah,
sure, I'm
yeah.
Josh again. Yeah, so thanks.
Still Josh.
So there's been talk about, a lot of hearings regarding the efficacy of these programs, and numbers coming out about the fact that even Obama's appointed review board couldn't actually find a single instance in which any of these programs had stopped, had resulted in a terrorist attack being stopped. So even if these programs are within the even if the collection programs and the warrants that are being issued are within the bounds of what's legally acceptable, doesn't it pose a problem if there's no justification for having them, even if there's no reason for not doing them, but there's also no reason for doing them?
That's the reason at the very beginning I said that one of the checks in the system that no one ever talks about is the executive branch. Because the fact that the agencies are authorized to undertake certain activities doesn't mean that they have to undertake those activities. And if you can convince an administration that there is no justification for that, I would think the administration would stop the practice. The difficulty is that we're in an arena where virtually all the players, including a current administration headed by a president who no one ever called a conservative, all right, are resolving all doubts in favor of what the intelligence professionals say is necessary for national security. And to me, that's understandable that people would do that, but it's a very tough political sell. I'm not talking about getting support, out at a rally, but to get a congressman or senator to vote, or a president to take executive action contrary to what the intelligence community is telling him or her is necessary for national security. And I don't really know how you handle that problem, but I think we both know that there haven't been many profiles in courage among the elected politicians in this area.
Judge Selya, I have a question for you, and it follows up on Peter's earlier question about does the system work? And I think, aside from what kinds of safeguards might exist or not exist, et cetera, but I was really taken by the description, the human side of this whole system. So it's staffed by overworked judges who have to do this on top of their regular loads. The story about the courier sounded scary, and then the locksmith even more scary. So it seems like it's an incredibly fragile.
Well, welcome to the use of your tax dollars.
So it seems like an incredibly fragile system based on the backs of goodwill, dedicated people. But at some point, you could imagine, as the system ramps up or continues to ramp up with additional technology, the system is really, really fragile. So how do you, is there any way to actually strengthen the human dimension or the organizational dimension?
No, because human error is always part of the equation in any of these things. And there has been some discussion from time to time about whether, for example, you want the judges who serve on the FISC and the FISCA to devote their full time to those endeavors. But that goes contrary to the whole notion of the way the federal judiciary is set up, and my own experience was, and I think I'm probably unique in the country. Someone in Washington told me a month ago that there are two major courts of this type, which are courts outside of courts. One is the multi-district litigation court, the other are the FISA courts. And someone told me a month ago that I'm the only federal judge who's ever served on both of them. All right? And what I find is, and the multi-district litigation is set up the same way, staffed by federal judges who have their own duties. What I find is that judges on these specialized courts put that work first. They realize that that's in our trade, that's considered a recognition of having achieved a certain status, because you pick up the phone and the Chief Justice of the United States calls and says, I want you to do this. Well, that's meaningful. And so what judges do is they tend to put that even before their own work. And I know, at least in my case, all right, that although I didn't avail myself of it, I know I had a number of colleagues on the circuit court who said to me often, if things get hectic, if you seem to be spending a lot of time on that, if you want me to take some of your caseload on our court, just say the word, So there's a lot of camaraderie that goes on. But it is fragile, and I don't know any way, unless you could devise a system that doesn't include human beings. I don't know how you get through with that fragility. I mean, the only way to completely avoid all mistakes is either with a supercomputer like Watson, good name, right? Or to marry my wife. I know of no other mistake-proof endeavor.
Well, on that very nice note, please join me in thanking Judge Selya for a really wonderful and informative session, and please join us at the reception outside right afterwards. Thank you. That was terrific.